আর মাত্র কিছু মাসের মধ্যেই লোকসভা নির্বাচন 2024 অনুষ্ঠিত হতে যাচ্ছে এবং তার আগে শীর্ষ আদালতের এক ঐতিহাসিক রায় সামনে এলো। ভোটের বদলে নোট নিলে আর রক্ষা কবচ থাকবে না। ঐতিহাসিক রায় দিয়েছে ইতিমধ্যেই শীর্ষ আদালত। শীর্ষ আদালতের বেঞ্চ জানিয়ে দিয়েছে, ভোটের বদলে যদি নোটের অভিযোগ উঠে আসে তাহলে সাংসদ অথবা বিধায়কদের কোনো রক্ষা কবচ দেওয়া হবে না, অর্থাৎ কোনো উপায়ে তারা ছাড় পাবেন না। শীর্ষ আদালতের এই ঐতিহাসিক রায়, তাও আবার লোকসভা নির্বাচনের প্রাক মুহূর্তে, রাজনৈতিক দলগুলিকে অনেকটাই ভাবাবেগে পূর্ণ করেছে। ব্যুরো রিপোর্ট, সোশ্যাল বাংলা।
Which were vested after between Parliament and the King. Privileges in pre-independence India were governed by statute in the face of a reluctant colonial government. The statutory privilege transitioned to a constitutional privilege after the commencement of the Constitution. 3. Whether a claim to privilege in a particular case conforms to the parameters of the Constitution is amenable to judicial review. 4. An individual member of the legislature cannot assert a claim of privilege to seek immunity under Articles 105 and 194 from prosecution on a charge of bribery in connection with a vote or speech in the legislature. Such a claim to immunity fails to fulfill the twofold test that the claim is tethered to the collective functioning of the House and that it is necessary to the discharge of the essential duties of a legislator. 5. Articles 104 and 105 and 194 of the Constitution seek to sustain an environment in which debate and deliberation can take place within the legislature. This purpose is destroyed when a member is induced to vote or speak in a certain manner because of an act of bribery. 6. The expressions anything and any must be read in the context of the accompanying expressions in Articles 105(2) and 194(2). The words in respect of means arising out of or bearing or a clear relation to, and cannot be interpreted to mean anything which may be even have a remote connection with the speech or vote given. 7. Bribery is not rendered immune under Articles 105(2) and the corresponding provision of Article 194 because a member engaging in bribery commits a crime which is not essential to the casting of the vote or the ability to decide on how the vote should be cast. The same principle applies to bribery in connection with a speech in the House or a committee. 8. Corruption and bribery by members of the legislatures erode probity in public life. 9. The jurisdiction which is exercised by a competent court to prosecute a criminal offense and the authority of the House to take action for a breach of discipline in relation to the acceptance of a bribe by a member of the legislature exist in distinct spheres. The scope, purpose, and consequences of the court exercising jurisdiction in relation to a criminal offense and the authority of the House to discipline its members are different. 10. The potential of misuse against individual members of the legislature is neither enhanced nor diminished by recognizing the jurisdiction of the court to prosecute a member of the legislature who is alleged to have indulged in an act of bribery. 11. The offense of bribery is agnostic to the performance of the agreed action and crystallizes on the exchange of illegal gratification. It does not matter whether the vote is cast in the agreed direction or if the vote is cast at all. The offense of bribery is complete at the point in time when the legislator accepts the bribe. And 12. The interpretation which has been placed on the issue in question in the judgment of the majority in P.V. Narasimha Rao results in a paradoxical outcome where a legislator is conferred with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but eventually decides to vote independently will be prosecuted. Such an interpretation is contrary to the text and purposes of Articles 105 and 194. We provide an overview now of the history of parliamentary privilege in India, followed by the purport of the privilege in India. I will read a few extracts from the judgment and the test to be applied. While some cherished freedoms exercised individually by members of the House, including the freedom of speech, have been undeniably understood to be essential to the functioning of the House as a whole, such exercises, such as damaging public property or committing violence, are not and cannot be deemed to have immunity. The privileges and immunities enshrined in Articles 105 and 194 of the Constitution with respect to Houses of Parliament and the legislatures, their members and committees, respectively belong to the House collectively. The exercise of the privileges individually by members must be tested on the anvil of whether it is tethered to the healthy and essential functioning of the House. The evolution of parliamentary privileges, as well as the jurisprudence of this court established, that members of the House, or indeed the House itself, cannot claim privileges which are not essentially related to their functioning. To give any privilege unconnected to the functioning of the Parliament or legislature by necessity is to create a class of citizens which enjoys unchecked exemption from ordinary application of the law. This was neither the intention of the Constitution nor the goal of vesting Parliament and legislatures with powers, privileges, and immunities. We therefore hold that the assertion of a privilege by an individual member of Parliament or legislature would be governed by a twofold test. First, the privilege claimed has to be tethered to the collective functioning of the House, and second, its necessity must bear a functional relationship to the discharge of the essential duties of a legislator. We then proceed to apply the above exposition of law to the context of a legislator who receives a bribe to cast a vote or speak in a certain direction. We hold that bribery is not protected by parliamentary privilege for the following reasons. The words anything and any, when read with their respective operative words, mean that a member may claim immunity to say as they feel and vote in a direction that they desire on any matter before the House. These are absolutely outside the scope of interference by the courts. The wide meaning of anything and any, read with their companion words, connotes actions of speech or voting inside the House or committee, which are absolute. The phrase in respect of applies to the collective phrase, anything said or any vote given. The words in respect of mean
20 নভেম্বর থেকে রাধাকৃষ্ণ জুয়েলারিতে শুরু হয়েছে বিবাহ মঙ্গল উৎসব, যেখানে সোনার গয়নার মজুরিতে 20% ছাড়, হীরের গয়নার মজুরিতে 100% ছাড়, আর মেগা ড্রতে 2 দম্পতির জন্য গোয়াতে হানিমুন প্যাকেজ সব পাবে।
ও মা, এ তো দারুণ খবর গো।
হ্যাঁ, আর বিয়ের গয়নার প্যাকেজ শুরু মাত্র 1 লক্ষ টাকা থেকে।
তো আজই চলো রাধাকৃষ্ণ জুয়েলারি,
উষাবাজার, আগরতলা, ধর্মনগর ও বিলোনিয়া।
রাধাকৃষ্ণ জুয়েলারি, সবার সাদর আমন্ত্রণ।